So if a terrorist group launches a missile at your country from across a sovereign border,
Right.
common sense says you shoot back,
Yeah.
right, to protect your citizens.
Exactly.
But under international law, doing that might actually make you the global criminal.
Yeah, it's a huge paradox.
Welcome to the War Room, everyone. Today we were doing a deep dive into the exact legal and strategic frameworks of cross-border retaliation. We're moving way past the daily news cycle to bulletproof your understanding for your exams.
I mean, that's the core mission of the strategic briefing. We are looking at a fundamental clash in global governance. On one hand, you have a nation's absolute right to self-defense.
Right, survival, basically.
Exactly. But on the other side, you have this international rules-based order from 1945 that is, terrified of endless war and built specifically to freeze borders permanently.
And to ground this analysis, we're pulling from two massive trigger events in our source files today. India's Operation Sindoor, which was a precision strike following the Pahalgam terrorist attack. And we're also looking at the April 2024 exchange between Israel and Iran. Israel struck the consulate in Damascus on April 1st, and Iran fired back at Israeli bases on April 13th.
Right. And those two events are perfect contrasting data points for you to remember. The Israel-Iran exchange is your classic state versus state conflict.
The traditional model.
Exactly. But Operation Sindoor represents the really murky reality of fighting non-state actors. To understand either of them, you have to grasp the structural problem first.
Which is, how do you legally justify firing weapons across a border without being branded an aggressor?
Spot on.
Because, the UN Charter is like a strict homeowners association rule book. Rule number 1 is basically you cannot attack your neighbor's property.
That's a great analogy. And that HOA rule is Article 2, Bracket 4 of the UN Charter.
Article 2, Paragraph 4. Right?
Yeah, this is your first major data anchor. Write it down. It is the general prohibition on the use of force. It explicitly bars member states from attacking the territorial integrity of any other state.
Because, they wrote this right after World War II, right?
Right. The architects were traumatized by those massive cross-border invasions, so they made state sovereignty the most sacred rule on Earth.
But they couldn't just outlaw self-defense entirely. If an army marches in, you can't just sit there.
No, of course not. And that brings us to the exception, which is Article 51. This is the legitimate self-defense clause. But, it's not a blank check.
Right, there are strict conditions.
Very strict. First, you need an actual armed attack. And second, your response has to follow two pillars of customary international law: necessity and proportionality.
And let's clarify that for the listeners, because necessity means basically you've exhausted all diplomacy. Force is the absolute last option.
Yes, exactly.
And proportionality isn't just matching weapons. It means your response is strictly calibrated to stop the threat.
Right. So if someone hits your border outpost with a drone, you take out the drone base. You do not get to, carpet bomb their capital city.
Surgical strikes only.
Exactly. And there's a procedural mandate, too. You have to immediately notify the UN Security Council.
Which we saw in the April 2024 data point.
We did. Iran officially notified the Security Council right after its April 13th retaliation, explicitly invoking Article 51.
And India did the same thing after the Pahalgam attack, right?
Yes. India briefed the majority of the UNSC members right after Operation Sindoor to fulfill that exact mandate.
Okay, so the traditional framework is pretty clean. Article 2, Paragraph 4 says no force. Article 51 says self-defense is okay if it's necessary, proportional, and you tell the UN.
In theory, yes.
But here's where I want to push back, because this framework totally collapses with modern threats.
It really does.
Iran versus Israel is state military versus state military. The UN Charter gets that. But what if the attacker isn't a government? What if a state is attacked by an independent terror group hiding next door?
That right there is the massive legal vacuum of modern counterterrorism. And to understand it, we need to look at a vital legal precedent from 1986.
The Nicaragua versus United States case.
Exactly. At the International Court of Justice, the ICJ ruled that an armed attack under Article 51 only triggers the right to self-defense against non-state actors if they act, quote, by or on behalf of a state.
Wait, so let me get this straight. Under that 1986 ruling, if an independent terror group attacks my citizens from across the border,
yeah,
and I can't prove their host government explicitly ordered it, I don't have the legal right to cross the border and stop them.
That is the exact trapdoor the ICJ created.
That's crazy.
Well, remember the context. It was the Cold War. The ICJ was trying to stop superpowers from using minor rebel skirmishes to just invade and topple governments.
Ah, right. They wanted a super high threshold for intervention.
Right, but the unintended side effect was creating this massive shield for independent terror groups. The victim state is just trapped by Article 2, Paragraph 4.
Which is an impossible security dilemma. No country is going to just let its citizens be attacked because of a loophole from 1986.
Exactly. Necessity drives evolution. And that leads us directly to the strategic solution, which is the unwilling or unable doctrine.
The unwilling or unable doctrine. Okay, let's unpack that.
It basically argues for an implied exception to state sovereignty. It says a victim state can use cross-border force against terrorists if the host state is, well, either unwilling or unable to stop them.
Because sovereignty comes with responsibility.
Precisely. If you claim a border, you have to make sure terrorists don't use your land to launch attacks.
And if you fail, you lose that absolute territorial protection.
Right. And the textbook example of this was the 2011 U.S. operation against Osama bin Laden in Pakistan.
Oh, wow, of course.
Yeah, the U.S. military bypassed Pakistani sovereignty entirely. They argued Pakistan was either unable to find al-Qaeda or unwilling to arrest them.
So under this doctrine, the U.S. had the right to step in.
Exactly.
But let me play devil's advocate for a second. We're looking at this from a very Western allied perspective. Don't countries like Russia and China heavily criticize this doctrine?
They absolutely do, and we have to evaluate that impartially. From their perspective, the unwilling or unable doctrine is a Trojan horse for imperialism.
Because who decides if a state is unwilling?
Right. They argue it gives powerful militaries a permanent blank check to just violate borders. If the threshold is just a subjective claim that your neighbor is unwilling to enforce the law, then state sovereignty is dead.
It really is a razor's edge between national survival and global stability.
Yeah.
Which brings us to India, right? How did India use this framework after Pahalgam?
Well, India knew they needed a robust legal foundation. Operation Sindoor wasn't just a kinetic strike. It was a profound shift in strategic policy.
Moving away from passive endurance.
Exactly. For a long time, India absorbed attacks to keep the moral high ground. But Sindoor marked a definitive pivot to strategic autonomy and, proactive capability demonstration.
But they still had to navigate that Nicaragua loophole so they wouldn't be sanctioned.
Right, and this is crucial for your exams.
Yeah.
India laid out its legal doctrine very carefully at a UNSC ARIA formula meeting in February 2021.
Okay, pause. What is an ARIA formula meeting? That just sounds like, I don't know, UN red tape to me.
It's actually the opposite. An ARIA formula meeting is an informal, highly confidential gathering of Security Council members.
So no official vetoes.
Right, no rigid protocols. It lets states present evidence, bring in experts, and build legal consensus without paralyzing official votes.
Oh, so it's like a high-level briefing to the global jury to set the narrative.
Exactly. And at that 2021 meeting, India didn't just demand a blank check. They set 3 very strict conditions for when the unwilling or unable doctrine is justified.
What were the 3 conditions?
First, the victim state has to prove the non-state actor has repeatedly attacked them.
Okay, so establishing necessity. It's an ongoing threat.
Yes. Second, there has to be clear evidence the host state is totally unwilling to neutralize the threat, even after diplomatic warnings.
Makes sense. And the third?
The third is the analytical masterstroke. India argued you must demonstrate the host state actively supports or sponsors the terrorists.
Wait, so they basically fused the new unwilling or unable doctrine with the old 1986 Nicaragua rule about state sponsorship.
Yes. It was brilliant legal architecture. By requiring evidence of state sponsorship, India addressed the fears of nations worried about blanket imperialism.
They're saying we aren't invading weak countries for fun. We're striking states that use terrorism as a literal government policy.
Exactly. It justified Operation Sindoor not just as retaliation, but as lawful enforcement of security norms.
Which ties right into Atmanirbhar Bharat, right?
Yeah.
Self-reliance applied to national security. India is saying they won't outsource their safety to slow UN resolutions anymore.
Perfectly stated. Its capability demonstration merged with strategic autonomy. And that's the interlinking engine you need to show for top marks.
Speaking of marks, let's pivot to our answer writing mentorship session.
Let's do it.
If you, the listener, are sitting down to write a 250-word exam answer on the legality of cross-border counterterrorism, how should you structure this?
Okay, grab your pens. You start with the context. Define the tension between Article 2, Paragraph 4, sovereignty, and the rise of non-state actors. Show that the 1945 law is struggling with modern reality.
Right, like analog software running a digital war. What's next?
Then the dimensions, or body 1. Contrast a traditional Article 51 conflict, like Iran-Israel, with the 1986 Nicaragua ruling, show how the ICJ created that loophole.
Okay, then body 2 is the challenges and the solution.
Exactly. Introduce the unwilling or unable doctrine, cite the 2011 U.S. operation, and then localize it immediately with India's 2021 ARIA conditions and Operation Sindoor.
But make sure to include the critical evaluation, right? Mentioning Russia and China's sovereignty concerns so you stay balanced.
You have to. That proves high-level analytical thinking.
And finally, the way forward. What administrative vocabulary should they use for the recommendations?
Use terms like institutional strengthening and normative frameworks. You want to recommend that the UN needs reform to officially define guidelines for non-state actors.
So push for international cooperation to close the gaps, basically.
Right, to ensure self-defense doesn't just turn into unilateral vigilantism.
That is such a solid, battle-tested structure.
Okay.
We are nearing the end of our War Room briefing, so it's time for the final revision capsule. Let's rapid-fire the 5 must-remember facts so you have them locked in.
Ready. Fact 1, Article 2, Paragraph 4 of the UN Charter, the strict prohibition on the use of force.
Fact 2.
Article 51, the self-defense exception governed by necessity, proportionality, and UNSC notification.
Fact.
The 1986 Nicaragua case, the ICJ ruling that required direct state sponsorship for cross-border strikes.
Fact 4.
The unwilling or unable doctrine, the modern workaround to that loophole popularized by the U.S. in 2011.
And fact 5.
India's February 2021 ARIA formula meeting, setting the 3 strict conditions that legally justified Operation Sindoor.
Perfect. And if you're highlighting analytical keywords, make sure you underline necessity, proportionality, non-state actors, sovereignty, and strategic autonomy.
And for your probable exam question, prepare for the specific prompt. Critically analyze the unwilling or unable doctrine in the context of Article 51, state sovereignty, and India's evolving national security posture.
If you followed this deep dive, you have everything you need to crush that prompt. But before we sign off, I want to leave you with one final provocative puzzle.
Oh, I like these.
We spent this whole time talking about how the unwilling or unable doctrine is becoming a practical necessity now. But zoom out for a second. If this becomes unquestioned international law, who gets to be the objective global referee?
That's the million-dollar question.
Right. Who has the real authority to look at a sovereign nation and definitively say they're unwilling rather than just structurally incapable? Does normalizing this framework actually protect the innocent, or does it quietly rewrite the UN Charter so powerful militaries never have to respect a border again?
I mean, it really is the defining geopolitical question of our era, a true test of whether the rules-based order can even survive its own evolution.
Definitely something to consider as you review your strategic notes today. Thanks for joining us in the War Room. Keep analyzing the structures behind the headlines, keep questioning the frameworks, and we'll see you on the next deep dive.